I've already read through this document, but the document I had before didn't have the exhibits attached. So, if you, I guess I'll just read it. But a summary: Lita Walker, under penalty of perjury, subject, declare as follows: that attorneys defending Netflix and above captioned action have personal knowledge of matters set forth herein. I may make this declaration in support of defendant Netflix Incorporated opposition to plaintiff's motion for order imposing sanctions and cross motion for award attorney fees on March 12, 2020, before the parties held a Rule 26 conference. Counsel for plaintiff Andrew Colborn improperly served on Netflix what was captioned as second set of requests for production of documents, a copy of which was filed as Exhibit 1 to the declaration of April Rocklead Baker. In following weeks, I conferred repeatedly with Ms. Baker via telephone and email regarding those requests and discovery issues more broadly as a reflection of those emails, which we're going to look at now. I read all this in the previous video I did, well, the second video. But these are the exhibits. Exhibit A, email. Hi, April. With the mediation behind us, we are cognizant of the Judge Lubig's statement back in December that discovery responses will be due 2 weeks after he rules on the pending motions to dismiss, should any portion of the case survive. So as to avoid any surprises, we wanted to put you on notice that Netflix plans to respond only to plaintiff's second requests for production of documents to Netflix, which were served March 12, 2020. We also provided second requests for production of documents to Netflix, which were served March 12, 2020. We will also provide second requests for production documents to Netflix Incorporated, which were served March 12, 2020. We also provide initial disclosures within 2 weeks of the court's ruling, assuming the case against Netflix is not dismissed in its entirety. We do not plan to respond to the first set of discovery requests served with the state court compliant nearly 2 years ago. Those discovery requests were rendered null and void by the removal to federal court. If you wish to properly serve those requests pursuant to the federal rules, we will answer them in time frame provided by the rules, or 2 weeks after the court rules on pending motions. Whichever is later, we do hope that, before serving those requests, you'll consider developments in the case over the past 2 years and tailor the requests accordingly so that it simply matters are avoided unnecessary disputes. Sincerely, Lita Walker. Exhibit B. External. Kevin and Lita. I am attaching the red line protective order that you sent with one change to the preamble. We do not know that there really is information that warrants production under seal. We are willing to stipulate the entirety of the protective order, facilitate a receiving discovery. So we're not comfortable with stipulating the broad factual representations that may be applicable in other cases. If we cannot finalize this, please let me know so we can e-file it and make arrangements for production responsive documents. Exhibit C. April. In light of making plaintiff's position clear as Wednesday's status conference, Judge Lubig's comments regarding the approach to protective orders generally, I thought maybe we should just propose the ED Wisconsin model protective order without any changes, a style that is stipulation, but I drafted a stipulation to make clear that the parties, including plaintiff, were entering into out of desire to expedite discovery, but it is in defendants who are representing that they believe confidential material will be produced. As I understand, that you did not want to see as making any admission to the score at this point. Please let me know your thoughts. Best, Kevin. Hi, Kevin. This issue made counsel favor styling to request a protective order and oppose the motion rather than a stipulation. I'm thinking the motion could indicate something to the effect that plaintiff's counsel had advised that the interest of expediting the exchange of discovery materials, they did not object to entry of the proposed protective order. Then it would make perfect sense to replace the preamble with something to effort of based on an imposed motion of defense Let me know if this approach will solve the problem. Thank you, April. With regard to your red line in the preamble of page 1, I think you understand the concern. However, Section D of the ED Wisconsin Modular Protective Order gives plaintiff the opportunity to challenge confidentiality designations. The reason I raise this is because I worry that deleting the language in the preamble might lead Judge Lubick to believe that the parties are in fundamental disagreement whether a protective order is appropriate when all parties want one, even if somewhat different reasons, at least at this point, although please keep in mind that we may ask Ms. Colborn for materials and discovery that he may want to designate confidential too. To further address your concern, we're not in the separate stipulation which you and I discussed were accompanied to proposed protective order. The parties will request protective order, expedite exchange of discovery. It is defendants who believe that the discovery will entail production of confidential information. I am attaching the red line protective order in a sentence with the change of preamble. We do not know that there is really information warrants production under seal, but we want to stipulate the entry of the protective order to facilitate the receiving discovery, so we are not comfortable stipulating the broad factual representations that may be flexible in the cases. If we cannot finalize this, please let me know so that we can e-file it and make arrangements. Exhibit D. Colborn versus Netflix. Dear April, I'm writing as we begin drafting our opposition to your recently filed motion for sanctions in the above referenced case in hopes that we will withdraw the motion. If you elect not to do so, we want the record to be clear that we advise you of the following. For the reasons discussed below, the motion is meritless. It burdens not only Netflix, but the court with briefing and issues that are not really issues at all. Discovery in the case is proceeding accordingly to schedule, and Netflix has in no way failed to comply with the obligations under federal rules or any other court. Indeed, as I told you when the last spoke on September 16th, we accept Netflix production of documents responsive to pending requests and enlarged by complete by mid-October with the opposition or motion to do. You spoke with co-counsel James Friedman about the meritless nature of your motion, but refused to withdraw it. Thus, we write to make a final written request for withdrawal. If you do not withdraw the motion and we are forced to oppose it, we will seek attorney fees. If you believe the summary below of our prior conversations and correspondence is inaccurate in any way, please advise immediately. Your motion for sanctions is inappropriate for the following reasons. First, you failed to meet the converter. Instead, you filed the motion without any warning after a productive discussion on September 16th, in which you agreed to discuss with our co-counsel that the terms of draft ESI protocol and how parties could sequence the representative discovery obligations. You did not threaten during the call to bring a motion to compel. Certainly you did not threaten to bring a motion to sanctions or attempt to meet the converter in good faith on the issues raised in your motion. I summarized our conversation in the email to you after the call, and I asked you to advise if you had different understanding of where things stood. To this date, I have not received a response to the email. Instead, after 8 days of silence and without any follow-up communication regarding the issues in which you promised to revert, you filed your motion. Suffice to say, we shocked to receive it, especially because both the federal rule and civil procedure require that the parties meet confer prior to filing discovery-related motions. Second, setting aside your failure to address discovery issues in good faith and to attempt to resolve them without involvement in the court, your motion in relief seeks entirely inappropriate. Procedurally, it is inappropriate because it jumps over the logical first step of the motion to compel and cannot point to Netflix violation of any federal rule of court. Order granting motion compel usually required to imposition of Rule 37 sanctions, except where a non-compliant party has received notice that the certain discovery proceedings are to occur by a specific date and then refuses to comply. Substantively, it is inappropriate and is scorched earth request for a sanction that would deprive Netflix the raising a constitutional defense. The First and 14th Amendment guarantees require, we think, federal rule that prohibits the public official from recovering damages for defamatory falsehood relating to his official conduct unless he proves that the statement was made with actual malice and in fact was inappropriate because Netflix had worked diligently to comply with discovery obligations. Here's the sequence of events that we will lay out in the court if we're forced to oppose your motion for sanctions. You filed this case in the state court in December 2018, but not served defendants until March 2019. The defendants timely removed the case in April 2019, at which point the timing and sequence of discovery became covered by Federal Civil Public 26. Defendants collectively filed 3 separate motions to dismiss for a variety of responses, all beyond the parties' control, including global pandemic, numerous judicial recusals, and reassignments. The last of these motions were not decided until May 26, 2021, more than 2 years after the case was removed. Meanwhile, the parties did not reconduct the Rule 26 conference until May 2020 in their joint report following the conference. Defendants requested that discovery be stayed from formal stay of discovery ever issued, but the parties in the court essentially operate as if they stay were in place. Following the May 2020 conference, the event that triggered plaintiff's ability to serve discovery rule, your client waited more than a year until June 2021 to do so. Moreover, Judge Ludwig made clear to the parties that December 17, 2020 status conference that he did not expect defendants to engage in discovery until after he decided the pending dispositive motions. Your client did purport to serve 2 sets of discovery prior to Rule 26 conference in contravention of the federal rules. You served 1 set with the original complaint filed in the state court before the lawsuit was removed from federal court, before the original complaint was amended. Not once, but twice, and before the count dismissal plaintiff's negligence claim. You served a 2nd set in March 2020 after removal, but again before the Rule 26 conference, because Rule 26 does not permit discovery prior to Rule 26 conference. Purported service of the 1st and the 2nd sets of discovery did not trigger any obligation to defendants to respond. I explained this to you, including in an email sent to you March 15, 2021. Nearly 7 months ago to the date, you have never responded to the email, nor have you ever attempted to reserve the 1st set of discovery requests in accordance with the federal rules. Consistent with Judge Ludwig's instructions, we timely served Netflix initial disclosures in response to the obligation to plaintiff's 2nd set of discovery 2 weeks after the court denied pending dispositive motions. Those requests sought raw footage. Responding Netflix does not have any raw footage. We had informally told you the months prior, so plaintiff has known this for a long time. More than a month after Judge Ludwig's order on June 24, 2021, we received the client's 3rd set of discovery requests. We had begun working with Netflix to collect potentially relevant documents even prior to the receipt of this 3rd set, and we timely provided written responses and objections to the request on July 19, 2021. You never contested the scope of the written responses or objections. Thus, since early June, we have worked with Netflix to collect roughly 20,000 potentially relevant documents and to develop the test search terms targeted at reducing the review set of those documents likely to be responsive to 3 and only 3 pending requests for production. Our efforts resulted in a review set of nearly 8,000 documents, which we have been working diligently to review and produce on a rolling basis. We have already delivered 2 productions to you, and we expect it is substantially done production before motion sanctions can be heard. 3rd and finally, your sudden and extreme motion for sanctions makes no sense in the context of this case. Discovery does not close in the case until April 8, 2022, and summary judgment motions are not due until May 13, 2022. July 28, 2021 scheduling order. No depositions have been scheduled. Defendants actually proposed a shorter discovery period, but it was your legal term and Mr. Colborn who wanted more time. Likewise, it was your legal term who took nearly 8 weeks to approve the filing of the protective order in the case, and it's your legal team who refuses to engage on the language of a very basic and standard ESA protocol that we've sent you more than a month ago on August 26th. This is your legal team that failed to provide timely response to the Netflix first set of discovery requests, which was served upon you on September 3rd, 2021, in which you did not respond until October 6th, 2021. Seems like Colborn and them jumped the gun, because, yeah. For all your reasons, your motions, sanctions, meritless, and borders, and frivolous, fees are available on prevailing party in your discovery motion, and we will not hesitate to seek them if you do not immediately withdraw your motion for sanctions. During the call, September 16th, I explained to you that only category documents that might not produce mid-October are emails exchanged between Synthesis Films and Netflix. Obviously, both Netflix and the producer have financed the possession of these emails, and it makes no sense for two legal teams to review the same documents, nor does it make sense for them to receive two copies of every response. Non-privileged email defendants emerge among themselves. Thus, I disclose to you that I'm coordinating review of those documents with Kevin Vick, counsel for producers. Mr. Vick, in turn, explained to you that the law firm currently short-staffed and might take a few extra weeks. Yada, yada, yada. And that's it. So, yeah. As soon as something new comes in the case, I'll bring it to you. So, till next time.